Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me. Hello and welcome to a special interview for The Wire. Has South Africa done enough to provisionally order the halt in the war in Gaza? Has it taken sufficient measures to convince the International Court of Justice in The Hague that such an order should be meted out? That's one of the key issues I shall explore today with one of South Africa's leading lawyers, Nasreen Rajab-Budlender. Nasreen is a senior counsel at the Pan-African Bar Association of South Africa. She practices in the field of public and constitutional law and has acted as a judge of the High Court of South Africa on several occasions. Nasreen, let me start with a simple question. I'll come to the details of genocide later, but first, how compelling and convincing are the arguments made by South Africa in support of its request for provisional measures to stop Israel's military campaign in Gaza? Or did Israel carry conviction when it argued that it cannot stop because it still faces a serious threat from Hamas?
Yes, thank you very much for having me on your show, Karan. I'm delighted to be here. Let me start by saying this. I watched South Africa's arguments before the International Court of Justice, and I read their application very carefully. I've also watched Israel's response and in fact read the transcript thereafter very carefully. What struck me as I was doing this is twofold. First of all, of course, I'm a lawyer, but I'm also a South African. And as I watched South Africa appear before that court, it struck me that I felt an inherent sense of pride that South Africa was doing this. Now, if anyone that knows me will tell you that I have on many occasions been very critical of our government, and certainly I'm not. I don't shirk from that. But this intervention is critical. It's historic. It symbolizes South Africa as the only country in the world that was willing to come before an international forum and demand that Israel come and defend itself, explain itself. Our ambassador who started the proceedings began by referring to South Africa's own history of apartheid. He referred to Nelson Mandela's.
Oh dear, the line seems to have broken at that point.
Can you hear me now?
I can indeed, yes. Would you tell me, do you believe South Africa has done enough to persuade the court to provisionally order a halt in the war in Gaza?
Yes, I do. In short, I do. I say this, I began by saying I was proud of South Africa simply because of this. I could be proud of South Africa as a person, but critical as a lawyer. So I looked at their application and listened to their arguments critically. I do believe, having done that what South Africa presented to the ICJ was a very cogent, tight legal argument. Its application is full, it's replete with examples, every one of which are sourced primarily in UN sources. So these are not statements being made. They're not just simply political rhetoric or emotive statements. They are all statements being made with reference to credible sources, primarily the United Nations organizations. So the case, I believe, is a very compelling one. I think that one can argue about context and one can argue about in Israel's conduct, but the real question for the court is Israel committing genocide in Gaza? And
well, let's come to genocide later, because
Sure.
that will take years possibly for the court to actually decide. What we're hoping will happen in weeks is a decision about whether a provisional order should be given. You do believe that South Africa has said and done enough to convince the court to issue a provisional order to stop the war in Gaza. Briefly, tell me, why do you think the case for a provisional order is compelling?
Yes, I do believe they've done enough. I think it's compelling because, as our representatives argued, it is not that South Africa has to prove genocide at this point in order to justify obtaining the provisional measures that it seeks as interim relief. It is simply that we have to show, in layman's language, enough to show that there's a plausible case of genocide, that the ICJ must take steps to stop and prevent further conduct on the part of Israel. So with that standard in mind, I think the application certainly does that. I think that it would be very difficult for the court to find against South Africa based on what I've seen on the application and in their argument.
Let's then turn to that question, whether South Africa has established what you call a plausible case for genocide. Now, genocide is considered the crime of all crimes, and there is a very high bar that has to be reached before you can establish that genocide has happened. Israel, many people say, may be guilty of war crimes, it may be guilty of crimes against humanity, but what are the grounds for arguing that it's guilty of genocide? What are the grounds that establish that plausible case for genocide?
Yes. Well, I think to answer that question, one must look at the definition of genocide. And that's contained in the Convention on the Prevention and Punishment of Genocide. And I want to just refer you to bits of that definition. So genocide is any of a series of acts that are committed with an intent to destroy in whole or in part, and that's important, in whole or in part, a national, ethnical, racial, or religious group. And it includes the following conduct: killing members of the group, okay, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. Now, it seems to me, if you look at those five acts that would indicate genocide, that when you compare that to the case against Israel, and you evaluate Israel's answers to the case against them, that South Africa meets the requirements. And particularly the idea that the easy ones are killing members of a group, right? And of course, you'd have to be able to show that was accompanied with the requisite intent. And so a lot of South Africa's argument was focused on genocidal intent. What was the intent behind the killing, for example?
Absolutely. You're citing Article 2 of the Convention on Genocide. In particular, the ones that would apply here are Article 2A, B, and C. Let me bring to your attention the rejoinders that Israel made in its defense. And before I come to what Israel said in defense of the arguments made against it by South Africa, Israel in fact claimed that it began by saying that it's not Israel that's guilty of perpetrating genocide, but Hamas. The first point made by Israel was to say that Hamas's brutal killing of civilians, its burning of children, and its raping of women amounts to an attempt at genocide by Hamas against Israel. Now, I think everyone all over the world would accept that what Hamas did on October the 7th was brutal, it was savage. But how do you respond to the claim that it's tantamount to genocide perpetrated on Israel by Hamas?
Yes. Well, first of all, we must keep focusing on what's before this court. And what's before this court is not Hamas. So Hamas is not a state. This court has jurisdiction over state parties who follow who are signatories to the convention. So the court has no power to make rulings against Hamas. That's an important starting point. One can absolutely condemn the horrific acts that were committed on October 7th. But the focus for this court is on Israel's conduct post-October 7th. And whether
In other
that
words, what Israel was doing was attempting to deflect the argument. And secondly, it was trying to accuse a party that cannot be a party in front of the court, because the court can only have states as parties in front of it, and Hamas is not a state. So this was a deflection by Israel. Is that right?
Yes, I think that's correct. I think that if you look at Israel's argument and the way in which they chose to argue this case, essentially what they placed before the court was a series of highly emotive, and I understand the emotion behind it. These are emotive issues, but they chose to approach the court by saying, these are all the terrible things that are happening to Israel, and therefore we are justified in defending ourselves. That misses the point, quite frankly. What the court needs to look at is the nature of how Israel chose to defend itself.
But before, can I interrupt you, Nasreen? My apologies. Before Israel actually made what you call its emotional defense, and aiming to argue that it was only defending itself, it was not guilty of genocide, Israel also made a very important, but perhaps for some narrow technical point, which, if correct, could actually scupper the South African case at the outset. Israel argued right at the very outset that the case is only admissible if there is an established dispute between the two countries. In turn, that means there has to be an exchange of documents establishing the dispute. That hasn't happened, Israel said, because 2 days after South Africa submitted its note verbal, it filed the case on the 29th of December without waiting for Israel's response. Therefore, there has been no exchange of documents between the two countries. Therefore, a dispute has not been established. And to use the language of the Israeli lawyer, he said, this is not a dispute, it's what he called a unispute. Now, that technical argument, if accepted, could actually scupper the entire South African case. How would you respond to that argument?
Well, it's a legal argument. That's the first thing. And so the ICJ's jurisprudence on what is a dispute is what will guide the court here. And there's very little guiding this. So effectively, a dispute, what the court has previously said, a dispute will be determined objectively by what was the nature of the engagement. Now, Professor Dugard, who represented South Africa, took the court through a series of attempted engagements with Israel, a series of public statements that South Africa had very serious concerns that what Israel was doing amounted to genocide. He also took the court through all of the diplomatic steps of note verbal, for example, and Israel's conduct thereafter. And the essence of his case was to say, one, contrary to what the Israelis argued, there is no obligation to negotiate, right? Two, and I'll come back to the importance of that. Two, declaring something a dispute, there's no formal process. The ICJ statute, the convention doesn't say you have to do A, B, and C before we accept that this is a dispute. So court will look objectively at the engagements between the states and what was going on at the time contextually in determining whether or not there was a dispute. So South Africa has argued, I think fairly convincingly.
You're making a very important point. You're saying that the Israeli claim that there needs to be an exchange of documents to establish there is a dispute is not necessarily correct. A dispute between two countries, as far as the jurisprudence of the ICJ is concerned, can be established without an exchange of documents. Is that right?
Yes. What I'm saying is that there's no established process that South Africa ought to have followed. What you see is a debate between Israel and South Africa about whether what South Africa did was sufficient. And that's what the court will evaluate. For myself, evaluating South Africa's various steps before it brought its matter to the ICJ, my sense is that it is sufficient to get there. The real problem is that if one expects a long, complicated series of diplomatic engagements and negotiations, as Israel put it, in the context of genocide that is ongoing, when thousands of people are being killed every day, I would imagine that the court would say that that was not required of South Africa, because to do so would undermine their very case.
Okay, let's then come to Israel's defense against the charge that it's guilty of Article 2A, the killing of people. Now, that is the clearest and the most commonsensical definition of genocide, which no one can dispute. Israel argues that the high death toll, which has now exceeded 24,000, that the fact that over 60,000 are injured, another 7,000 apparently missing and untraced, and 1.9 million people have been displaced. Israel argues this is because Hamas has deliberately chosen to embed itself in civilian residential areas, in hospitals, and even in UN buildings. In other words, what Israel is arguing is that the high death toll, the high injury toll, the high displacement of people is not Israel's fault, but Hamas's fault. In other words, Israel's position is we aren't to blame for this death toll. Hamas's tactics and strategy are responsible. How would South Africa respond to that?
Well, I can tell you my response, and that is that that it's a weak response, because that Israel's response is weak, because to simply say this is not our fault, it's Hamas's fault, absolves Israel of any responsibility in how it chooses to conduct its military operations. There is no question that Israel has a right to self-defense. The question is, what does that right entail? Where are the boundaries of that right? And what we know very clearly as lawyers is that self-defense has limits within the bounds of international rules around war and humanitarian laws. So, for example, self-defense is never a justification for genocide. So when Israel says, we're so sorry, but Hamas has infiltrated civilian operations, and therefore we have to bomb hospitals and churches and mosques and schools, and including UN protected areas. We have to bomb those places because we think Hamas is somewhere in there. It does not preclude an analysis of whether that conduct is justified legally. That conduct, I would suggest, is not justified legally, because Israel, the way in which they've factually chosen to bomb and conduct land invasions is so wide-scale and disproportionate. They keep saying we're not targeting children, for example, but the places that they bomb, they know are full of children. So it's not a sufficient response to my mind.
Except that Israel also claims that it's made every effort to ensure that innocent people are not killed. It says it's airdropped flyers warning of imminent attacks. It's called civilians on their phones to urge them to vacate targeted buildings. It's even, it claims, aborted some strikes when civilians were believed to be in harm's way. More importantly, the Israeli lawyers argued that Israel's intention has been made crystal clear, and it is not to destroy the Palestinian people, it is to destroy Hamas instead. Now, how does that go down with you? These steps to prevent innocent people being killed, as well as the public declaration that our intention is not to destroy and kill Palestinian people, but to destroy and eliminate Hamas.
Yes, well, my reaction is one must take those public statements and evaluate them against what we see and know to be factually correct on the ground. And when one evaluates that, and if you just look at UN sources and credible NGOs such as Human Rights Watch, then you start to see that what is being said in court and by Israel's leaders is not what's happening on the ground. It's also not the message being given to its troops. So South Africa's application is replete with examples of statements that indicate genocidal intent. And that's a core part of what they need to prove to win this case. When one looks at neutral statements after South Africa's case being made by the Prime Minister of Israel, for example, saying we're not really interested here in genocide, we must protect civilians, that all happens, quite frankly, too little and too late. And it ignores the fact that the message being given to soldiers on the ground is kill at all costs and kill indiscriminately. When you have pictures that have not been disputed of the president of Israel signing missiles with his name and egging on soldiers to go and kill civilians, that does not sit well with these public statements of careful and measured war, if there is such a thing to begin with. So my response is that one really must critically evaluate what is being said against what we know factually to be true on the ground.
Now, the key behind the case is actually establishing genocidal intent. And a lot of the time taken up by the South African lawyers was, in fact, to critically establish that case. One of the points that was made by the South African lawyers was to cite Prime Minister Netanyahu's Amalek statement of 28th October. Israel responded to that specifically. Israel said that South Africa has plucked a few sentences out of context, that the full written statement of October 28th also includes the sentence, and I'm quoting, "We will do everything to avoid harming the uninvolved." And therefore, Israel's response specifically to the Amalek statement was that it is being misrepresented, it's been taken out of context, and when you see the full context, it doesn't amount to genocidal intent, particularly when the full statement includes that sentence, "We will do everything to avoid harming the uninvolved."
Mm. Well, context is an important word there, because in fact, first of all, the reference to Amalek is a horrific one in the context of war. If one looks at, in fact, the injunction from King Saul, it was to kill indiscriminately, to not spare anyone, not children, not infants, not animals. So that's the first thing. The choice of that reference speaks volumes. Secondly, when one looks, and this is why I come back to context, when one takes that statement of Netanyahu and you compare it to what his ministers are saying, there were several ministers who said no one is uninvolved. Now that's an important word because it's interesting, comes back into his statement. No one is uninvolved. When one accepts, as soldiers on the ground do, when their ministers tell them no one is uninvolved, and then your prime minister says you must go and follow through as you were given the injunction in the Bible to do, and only attack people that are uninvolved, it's very clear. It means that you attacked indiscriminately.
I take your point, but again, there's a specific statement that South Africa quoted, the statement made by Heritage Minister Amihai Eliyahu, where he talked about dropping a nuclear bomb on Gaza. Again,
Yes.
Israel responded to that specifically. It pointed out, first of all, that Eliyahu had been repudiated by the prime minister. And secondly, it pointed out that he's not a member of the war cabinet.
Yes.
How would you respond to that?
Yes, I think that is true, and I accept that they sanctioned that particular minister. But it ignores the fact that there are a series of other ministers and ministers that have very critical portfolios. So, for example, we've had statements in the South African application and generally recognized, the New York Times carried an article on this the other day, that statements of this sort were made from the very top, from the prime minister, from the president, from the minister of the National Security Council, from the minister of defense, energy and infrastructure, finance, agriculture. So heritage is one of a long series of ministers that have been giving this message. And if you are an official in the army, if you're a soldier on the ground, if you're an ordinary Israeli, one must question what message you are receiving. When all of these different ministers in government are saying to you, this is our intent. Our intent is to erase and raise Gaza.
Well, that's what Israel questions, that whether these statements by ministers, and I accept there's a whole range of ministers who are guilty of making what Israelis like Danny Ayalon, a former deputy foreign minister, calls foolish statements. But these, Israel says, are not actually statements of intent. Whether the statement is made by the president, the prime minister, the defense minister, the heritage minister, agriculture minister, or national security minister, these, Israel says, are expressions of anger and anguish made in the heat of the moment. They may be foolish and indiscreet, but they do not, Israel argues, establish genocidal intent. More importantly, Israel says, they also don't reflect Israeli policy. The people making the statements, with the solitary exception of the defense minister, are not members of the war cabinet. They don't determine the war strategy the country is following.
Yeah, I mean, my response to that is it is simply not good enough. It is simply not good enough to sanction one of that long series of ministers that I referred to and allow everyone else to continue to speak in this way. In addition, Israel hasn't sanctioned the media that uses genocidal language, for example. We know that in other instances of genocide, such as in Rwanda, things like the media were used incredibly and terribly effectively to push a genocide and to impel it to take place. So I think it's not good enough to simply say these people speaking with this genocidal language and passing on a message to our country, to our defense forces, to people in charge of the weapons that are used to kill people. They are not part of our war ministry, and so they don't represent our policy in circumstances where you don't publicly sanction that to all Israelis and make that very clear. Israel now sends us minutes, for example, of meetings of the war cabinet where Netanyahu speaks fairly in a much more measured way about their military operation. But to his Israeli public, he speaks in very strong rhetoric, in words calculated to incite and inflame passions against the Palestinians.
I accept that Netanyahu is Netanyahu is embarrassing for the Israelis because he's the prime minister. He's clearly a member of the war cabinet. It's hard for him to excuse himself on the grounds
more than embarrassing
with emotion. But what about the wider point made by Israel that the ministers that you cited and the MPs, and leave aside the press, none of them are members of the war cabinet. The war strategy, the war policy is determined by the war cabinet, and the heritage minister or the agriculture minister or even people like Ben-Gvir and Somrich are not members of the war cabinet. They may be indiscreet, they may be foolish, but they cannot amount to expressing genocidal intent because clearly that intent doesn't translate into strategy because they're not members of the war cabinet. How do you respond to that key argument?
So the response is this. First of all, very few governments will declare genocidal intent. It's not something generally. In Rwanda, there wasn't a statement, we are now going to commit genocide against whoever. So that's number one. That's not what you look at. Sorry, have you got a problem with the line, Karan?
No, please carry on. Can you hear me?
Yes, I can hear you very well. So
please carry on.
Is that one doesn't expect a generalized statement and a public statement saying, today we're going to start a genocide. That's number one. What you look at is conduct. So you look at statements of the Minister of Defense, who is not sanctioned. You look at statements of the President and the Prime Minister, and it's not enough to say that the Prime Minister is an embarrassment. He is the Prime Minister. He continues to be the Prime Minister. He represents the country. He's elected to be there, and he and the country must be held to account for that. So when you have statements, yes, you can debate whether a statement by the Minister of Agriculture is sufficient. But what I was saying before is that one has to look at the overall cumulative effect of all of these ministers that are responsible for serious portfolios, energy and infrastructure, defense, and then the most senior, the Prime Minister and the President. That, I would argue, is sufficient to show intent, that you don't need a statement by the War Cabinet. What you need to look at is what the War Cabinet authorized to be done on the ground. And when we look at Israel's conduct and the wide-scale indiscriminate bombing and targeting of civilian infrastructure, civilian homes, hospitals, schools, mosques, etc., that conduct evidences genocidal intent.
So if I understand correctly, you're making 2 points in rebuttal of the defense Israel put up. First of all, it's almost inconceivable to believe that such a large number of ministers and MPs would all be foolish and indiscreet and not be expressing genocidal intent. You could make that argument if it was 1 or 2 ministers, but when you have a case of 6, 7, or 8 ministers, or virtually the entire cabinet, and a large number of MPs saying very similar genocidal things, then it's hard to argue that these are just foolish people being indiscreet. And the second thing you're saying is that look at the actual policy followed on the ground, authorized by the War Cabinet, when it leads to the deaths of over 24,000, to over 60,000 being injured, to 1.9 million being displaced, then quite clearly this is a disproportionate attack, which is tantamount to genocide. It is not self-defense. It certainly is not an appropriate response to what Hamas did. It's an exaggerated response verging on genocide. Have I summed you up correctly?
Yes, I think that's a very good summing up of my position.
In which case, tell me, did you get any sense of how the judges sitting at The Hague responded to what they were hearing either from Israel or from South Africa? Did you have any sense of what was likely to be their response?
You know, it's very difficult to tell. It's particularly difficult to tell if you're not sitting in that court. One, as a lawyer, one sits there and usually notes what judges are making earnest notes about, what they're particularly interested in. And certainly in South Africa, and I would imagine India, judges ask questions. And those questions usually elicit some engagement between counsel and the court, which gives an indication of what the court is thinking. In these proceedings, the judges are precluded from asking questions as a general matter. And so you would have seen that there were no questions asked. So it's very difficult to tell how the court's going to decide. We also know that these are judges that come from very different backgrounds and countries. They are independent, and I believe that they will act independently as judges. But yeah, as I say, very difficult to say at this point.
Now, since the case was heard, Germany has announced that it will make itself a party to the case on Israel's side. In, I imagine, response, Namibia has accused Germany of genocide in Namibia during the first decade of the last century. How will all of that affect the case?
Well, I think the German intervention is very interesting and quite astounding, quite frankly. First of all, Germany, yes, Namibia has come out very strongly against Germany and accused it of genocide in Namibia, as one of the first global acts of genocide. I think that's what the Namibian statement refers to. That's number one. Number two, Germany, interestingly, has also sought to intervene in the Gambia-Myanmar case. And in that case, they're intervening on the side of an accusation of genocide, and in support of a very wide accusation, a wide interpretation of the term genocide. So if Germany weren't to intervene on the side of Israel in this case, they would be taking a position completely contradictory to their position in the Gambia-Myanmar matter. And that would be an interesting conflict to debate. I am quite astounded that Germany would seek to intervene, given its own history. The last time I checked, they hadn't actually formally intervened. That will come in due course once there's been a determination of the provisional measures, I imagine. But they have indicated an intention to intervene.
But the interesting thing you point out is that Germany has effectively contradicted itself, because the position it's taken in the Gambia versus Myanmar case is almost the opposite of the position that it claims it's going to take in the South Africa versus Israel case. Let me end this interview by going back to the issue I started with. If the judges, and we'll know within a couple of weeks, I suppose, but if the judges issue a provisional order asking Israel to immediately cease its military campaign in Gaza, and Israel refuses to obey, which is what Netanyahu indicated on Saturday and Sunday, what do you think will be the response from South Africa? Because then South Africa would have got the provisional order it asked for. In response, Israel has made clear that it will not accept it, it will not obey it. So I imagine South Africa must already be thinking of what will be our response when that actually happens.
Yes. Well, first of all, it won't be the first time that a state has failed to follow the court's directions. The USA is guilty of that. And as you say, Netanyahu has publicly stated that he doesn't care what happens in the ICJ, is continuing nonetheless. South Africa would then be entitled to go to the UN Security Council and ask for a resolution there. That, of course, will in all likelihood lead to a veto by the US. So the bottom line is it may ultimately not achieve the desired outcome. But what it does achieve, I think, whether or not we obtain a ceasefire through this process, South Africa, through this application, has forced the airing very publicly, very globally, of these issues, has forced Israel to come in a global forum and defend itself and place on record its position. That has never happened before. And there is something incredibly important just about that, whether we succeed ultimately in obtaining the ceasefire, which we know, given the realities of global diplomacy and international law, may not happen. But I would imagine that there is a moral achievement here that surpasses any victory we may get through the court process.
So you're suggesting that the moral achievement, which is actually already successfully achieved, could weigh in the balance more importantly than actually the legal achievement, whether or not South Africa gets that provisional order. And we'll know, as I said, in a couple of weeks' time whether it's going to get it. The moral achievement has already happened. already the world's attention has been drawn irrevocably to something that till then the world may not have recognized quite as clearly and certainly not as forcefully.
Yes, I would imagine that so, and I would hope that it convinces other countries to reevaluate their positions. And we as citizens should be questioning our leaders about our positions, about our country's positions in relation to this dispute. And hopefully we'll achieve that, whether we achieve a ceasefire through the court process or not.
In other words, awakening the world to what was happening was perhaps more important than actually getting that legal order to stop it happening.
Yeah.
Oops, we seem to have lost you again, but we are right at the end of the interview with that last question. Thank you very much indeed, Nasreen Rajab-Budlender. I'm very grateful to you for joining me.
Thank you very much for having me.
Hi, I'm Karan Thapar. Over the last few years, I hope you've been watching my program, The Interview on the Wire. During that period, I've interviewed doctors, politicians, businessmen, scientists, authors, and even the occasional Nobel laureate. For me, it's been exciting. I hope it's been enjoyable for you. But these, as you know, are tough times, and if this program is going to remain bold, independent, and sometimes even defiant, then I think we need your support. At the end of the day, it's a truism, but editorial independence is best defended by the viewers. So if you would like this program to remain the way it is, forthright, outspoken, and interesting, then would you consider supporting us? All you have to do is to click on the description at the bottom. But more than anything else, I hope you will continue to watch the interview. Your viewership means an awful lot to me.